becomes vacant in the House of Parliament, the lower house, the other place. Resignation, expulsion, and crossing the floor. Expelled from the party, resignation from the party, or crossing the floor. Third thing I would like to speak to is the fact that we have a Constitution Reform Commission, or we had, and it issued its report. And as I will quote from a little bit later on, this particular provision was considered, but it was not recommended by the Constitution Reform Commission. But perhaps the situation is different now than it was then, when they considered it and debated it at that time. And that would lead us back to the why now. But the fundamental question that this particular amendment addresses, I think, is whether or not a person who is elected in their personal capacity, or are they elected on the party mandate? That's the fundamental question, and the only difference here that we're dealing with as I see it. And as you know, sir, I can't help but take a business approach. I am not a lawyer. I'm not a lawyer to this. I'm an accountant like you. I'm a quantity surveyor, or evaluation surveyor, and I'm a computer scientist. Those are the three things that I am qualified in. I am certainly not qualified in law, and this is for the legal scholars to deal with. But perhaps the approach that I take from a business point of view is I look at this and say, well, what does the law really say, the amendment say, and perhaps what are the unintended, I don't want to call it consequences, but perhaps, or the unhighlighted consequences of this. The first one that jumped out at me was the expulsion of an individual of a member of a political party becomes a powerful weapon against internal dissent within that party. And that troubled me. That troubled me. Because what we do not want to create is what is often referred to as an echo chamber. We don't want an echo chamber within the House of Parliament, within that lower house. We want robust debate, whether that debate sometimes comes from across the floor, or maybe comes from within itself. And is it not even more important, sir, when you have the third 30 Love mandate, that you ask for this type of robust debate and you do not thwart it with perhaps the threat of expulsion? Perhaps this legislation or this amendment to the Constitution will reduce what I would call conscious voting, where individuals search their own conscience and vote based upon that, as opposed to being based upon the party. But I have been told that expulsion is a serious matter. It's not taken lightly, and there's all kinds of due process with it, and there's all kinds of recourse to the courts, etc. And that is true within an organization that has a robust set of rules. But those robust set of rules, as Senator Rogers pointed out, they are unknown to the Constitution. You can set them all on your own. And my particular example I would give today, maybe this is frivolous and maybe it's a bit of a joke, but I'm also being serious. Perhaps, sir, within the Constitution of my party, whatever that party is that I belong to, perhaps one day we decide that wearing pink pantsuits on Fridays is grounds for expulsion. Yes. We could decide that, sir, yes, because that's what our party says. That's one of our rules. Yes. And if we have that as a rule, then you will be expelled. So we have to be careful, because expulsion from the party triggers the loss of the seat. And as Senator Rogers said, that is significant. Significant. And I'm not sure that our Constitution contemplated that. Now, if something like this did happen, whether it be for resignation, crossing the floor, or for expulsion, we have to recognize that these constituents who elected that person, they lose representation for perhaps an extended period. I've heard that the courts will deal with these matters expeditiously, and I understand that there's been evidence in the past of that actually happening, but there's no guarantee that it will happen. We could have built in to this amendment, given a specific amount of time in order to adjudicate. The 14 days, sir, is for you to go to the court. The court has no limitation as to how long before they rule. So that seat, immediately, you can't function in that seat, and until the court has ruled, you could have a situation where those constituents are without representation for a long time. In some other jurisdictions, they actually limit it, say the court must give a ruling within 60 days. Now, the third thing on this is the crossing of the floor. Now, I am not a politician, and I've said that over and over again, and that should be abundantly clear to everyone in here. I have no political affiliation at all. In fact, I think the political affiliation that I have is party and power. That's who I have to work with. That's how it works with the business community. Someone else chooses who is going to be in power, and then we work with whoever is in power. But crossing the floor, I heard in the other place the Prime Minister say this did not need to be explained. But maybe it doesn't need to be explained to some people. For me, I thought it would have been useful for it to be explained and be more laid out clearly what it was. Because if in fact it is so well understood, it would have been easy then to actually have articulated it within this same piece of legislation. And I'm worried that there could be arguments over what constitutes crossing the floor, because while it might be well understood, it certainly is not in writing anywhere. So I would not want to see a problem and any ambiguity around that. The other thing that worried me a little bit when I read this, and it has been explained to me, sir, that perhaps my fears are not well placed, was that the Speaker, who we have recently, within the last few months, made an independent person who is not a member of Parliament, elected member of Parliament, I'm a bit worried that we are putting the Speaker into a politically explosive situation, let's call it that. What I understand is that the declaration that is made by the leader of the House of the Parliamentary Business of the party of the candidate who was elected the member, I had to read that, sir, there's a lot, it's quite a mouthful. Once that declaration is made, the Speaker, following procedure, must trigger the vacancy. I am concerned that the act of creating this vacancy is done by the Speaker, is not done by the party itself. The party simply only declares. And it may only be words, and as I said earlier, I'm not a lawyer, but it seems to me that we may be putting the Speaker into a very contentious position there. Because the Speaker must take note of the notification, but what if he doesn't declare based upon that notification? The amendment, sir, also creates a possibility of, let's call it, engineered vacancies. So if a party believes that they could win a by-election and they don't particularly want a particular candidate, that would be a good time to do something about it. And that would be called an engineered vacancy. And I'm a bit worried that that is now created. And all of these things, though, I'm going to come back to. Remember what he said, what's the mischief that we're seeking to solve? Because sometimes you have to choose the lesser of two evils. Sometimes you have to do that. And maybe there's a bigger evil out there that we haven't yet looked at. Other thing that it doesn't address, that I was hoping that perhaps something like this, which if we spent a bit more time talking about, maybe we would have addressed it. What about when parties split? And I believe in our history, and I am no expert on it, but there are others in this room who might be. I believe there was a time when there were 3 or 4 members of one party that split off and did their own party. I think it may have been the NDP at the time. It was Richie Haynes and so on. So this doesn't deal with that at all, because if you have a split, which one is the real party? I don't know. I don't know how it would deal with if it's more than one person crossing the floor. If 3 or 4 split, what happens? The other thing that this doesn't address is that it specifically is speaking to if you are elected on one party's platform and you leave that and become an independent or go to another party, and there's been great discussion, I think Senator Slocum explained that quite well as to good reasons why that should in fact trigger. You've done all of these different things, as has been explained to me. You put yourself forward as a candidate for that party. That party within the little constituency it had, it said, yes, we choose you. And then you who were chosen go up to the bigger executive committee party, say, yes, we would like you. And then they throw their weight behind you. And you get all the benefit of everything they're doing. And you sign their manifesto. And you go to the polls and you're elected. To simply say that you can cross the floor after that or change and say disassociate yourself with the manifesto that you have signed on to certainly is a significant event. And as I say, Senator Slocum did a much better job of explaining that than I could. But it might come to pass that in Barbados, someone is an independent is elected. What happens when an independent then joins a party? Is that a triggering event here? Because that hasn't been talked about. What if you're elected as an independent and then you say, I really like Senator Sinclair's Democratic Labour Party, Barbados Labour Party, and I would like to join them. Is that a triggering event? Because that's the same thing. You're changing political associations at that point in time, but it has not been. Well, no, he joins another party, so that treats to the independents. So there are a bunch of other things that could have been considered in this amendment that perhaps would have made it a bit more robust. So I come back to, and maybe before I go there, let me just also quote from, I believe, sir, the report of the Constitutional Reform Commission has been laid in here as an official document, so I think I would be within my rights to quote from it. And I would say that on page 27 and continuing on page 28 of that document, and I quote, it says, the Commission discussed but did not ultimately agree to recommended provisions for the recall of MPs or restrictions on them crossing the floor. In either case, the majority felt that the essence of representative democracy was the people elect their MPs at periodic general elections with a mandate to represent them, and thus MPs must have the ability during the parliamentary term to act as necessary in pursuit of that mandate. I note, sir, that members of that commission are also members here now. Senator Rogers is a member of that commission. Senator Redmond, also a member of that commission. So that's the opinion. I don't know if they were part of there wasn't a dissent in it. Apparently it was considered, but it was not agreed. I don't know what that means exactly. In the other place, of course, Member of Parliament Gregory Nichols was also a member of that. So, sir, my conclusions on this would be, come back to why now? Why now? And maybe before I address that, I will use this occasion to share with you, sir, and the Chamber, what would have been my top 10 things if I had had the opportunity to deal with it. And I was going to deal with those top 10 things urgently. And I sat in here with you, sir, at the first sitting of this Senate, and we heard for the first time, I don't know if it's still called a throne speech, but the President's speech. And it digressed from what it normally does, because I would normally hear words like my government says, and my, you know, it says, look, those are not things that we said. The President told us what he thought was his priorities. It was rather refreshing what his thoughts were. So I thought I would share with you, sir, what my priorities would be. And perhaps the first one is going to come as a surprise to all, and maybe get me in trouble, as I like to do, apparently. What I would tell you is, right now, in my opinion, the world order has changed, and we need to recognize that. And what one of our national heroes, I think, is that correct? Errol Barrett? The Honourable? Yeah, get all the things correct. You're right, excellent, thank you. He said, and I think I have this right, is that we were friends of all and satellites of none. Sir, the world order has changed, and my number one thing might be to look at that carefully and see, can we continue to exist with that as our motto? Or do we need to pick sides? And I think that we're seeing around the Caribbean, people are picking sides. And that might be the new world order. So number one would be, I would take a look at that. Number two is crime, and I'm not going to spend a whole lot of time on this, so I'll rattle through it. Number three is indiscipline within our society, which is partly linked to the crime. Number four, private sector reform. I have heard of this for as long as I have been an adult. Public sector, thank you, public sector. Private too. And I would completely agree with both private and public sector, so thank you. I've adjusted my number four to say that. Because we need to recognize that while we are trying to reform, we actually need to revolutionize. Artificial intelligence is changing the way that we do business daily, and we are playing catch up with 20-year-ago stuff. Sir, I can tell you my own experience. I digress for another couple of minutes to share something with you. As you know, sir, I serve as a judge, let's call it. The stewards is what we call it in Formula One, in the racing world. And this weekend I will leave tomorrow. I will leave to go to the first race of the year. For the first time, what will I be doing? I will be using all of the regulations, all of the guidelines for penalties. The artificial intelligence will be watching the race. It will tell me when they think an infringement has occurred. Of course, I have the final decision, but it's going to help greatly in how quickly, how accurately that I am doing things. And when I could give you 50 different examples within my own business that we're adopting artificial intelligence at a rate that is significant. So when I add number four here, private and public sector revolution, that would be at the top of my agenda. Tax simplification would be at the top of my agenda. Facilitation versus frustration. We don't want me to talk about the F words here again, those two F words. Certainly don't want me to move on to the C words as I do from time to time and talk about concessions versus corruption. I would look at a national service program, sir, for those who are leaving school and are not academically inclined and are not perhaps going to the trade schools and so on. I would look for some type of national service program. As I've said in here, sir, before, I would look towards free public transportation as part of the solution to the congestion on the roads. I would look at our infrastructure, our airport, our port, our roads, our water, our sewage systems. And on the 10th, and it could be in any order you want because they're all equally important, is our healthcare system. So that would be, for me, what I would do now. But why are we in such a hurry with this particular one? And I would like to maybe throw out something here to the group that maybe has not been said, or maybe others have said it and I didn't understand when they said it. But sir, I think this amendment would likely strengthen an opposition and not weaken it. I suspect that had we had this amendment prior to the elections, we might have actually had an opposition. I think that the reality is, knowing that you can just simply move from one to the other gives you some comfort. But if you know that that's not so, you knew it in advance, I put forward to you, sir, that that might actually strengthen our democratic process, and it might strengthen the fact we might actually have had a few people in opposition. I don't think it might have changed, in my opinion, from what I can see. I don't think it would have changed the overall outcome, but I was surprised, certainly, at what it was. So, sir, why now is the question I started at the beginning. Why in such a hurry? Why digress from the recommendations that have been put forward? That's how I would answer that question, because we cannot in this country afford another 30 Love. We need a robust opposition, and in a two-party system with the other side so darn weak, so weak it seems, excuse my language there, I think that this perhaps as a alternative opinion, because I cannot disagree with anything that Senator Rogers said. But perhaps I may be different in the conclusion that I come to at the end, which is to say that there maybe the lesser of two evils is the way that I might have to reconcile it within my heart and head, that perhaps that is what we would do. So, sir, with those few words on this very important matter, I am much obliged to you.
Thank you very much, Senator Maladu. Speakers, Senator Goodrich.
Thank you, Mr. President. I wish to take this time to congratulate, first of all, myself for being a senator. And then I would like to congratulate all the other senators who are in the House today. Mr. President, I came to begin my presentation with a quote. I don't have it here documented, but I have it in my memory. And that quote is by Shakespeare. And that quote states, "There's nothing good or bad, but it's the thinking that makes it so." So the basis of that submission is to state that your perception will shape your reality. But of course, when we are dealing with the Constitution Amendment Bill of 2026, we have to carefully scrutinize it. And we are not just dealing with perception. This is a reality today, sir. And it has caused a lot of national debate in the country because, of course, the Constitution is the framework of the land. And if we are going to amend it, we have to ensure, sir, Mr. President, that democracy is upheld and that the fundamental rights and the freedoms of the people of Barbados that they have enjoyed for so long will not be taken from them or infringed. So as I reflect with that quote, I remind every senator and every citizen of this country that legislation must be properly scrutinized and it should be proportional and well justified when it is to be implemented, sir. So, sir, my integrity compels me to ask certain questions today. Because, of course, we know that there's a buzz on the floor going around that if an elected candidate who sits in this parliament does cross the floor, there goes me. But my political survival doesn't bother me with my statements today. I have to do what I have to do in terms of my integrity. So, sir, I'm going to ask these questions. And the questions that I want to ask are these. What is the benefit of this legislation at this time? What is the benefit of the bill? Because anytime a bill is to be passed, we must first look at the benefit of the bill on the rights of the citizens. Second question, what are the potential harms to the people of Barbados? So the third question is, what improvements can be made to increase the benefits or limit or remove the harms? And sir, I know that there are benefits when we think about anti-defection laws, because the whole idea is that when elected candidates are campaigning, they campaign under the banner of a party. And while they campaign under the banner of a party, there's a manifesto. And this manifesto they would agree to. And the manifesto is not just a fancy decoration. the manifesto comes like a covenant. Yes? So, as they agree to this manifesto, and then perhaps later decide they don't agree with it, or they want to cross the floor, then it would appear to the public that they have betrayed that said manifesto which they had agreed to. And even during my campaign, Mr. President, I was one who said, I am not opposed to the idea of anti-defection laws in principle. But I go deeper than that, because though I understand that there's voter apathy in the country, and people would pretty much agree that when members continuously cross the floor, it could, cause some voter apathy. But I want to add to that, that even though such legislation could compel members to stick to the manifesto and stick under that banner, I'm saying, if we are saying that they are to stick to the manifesto, just so that then there's democratic accountability. So I understand, yes. So I understand, yes, that this piece of legislation, sir, is to ensure political stability. But again, sir, that doesn't mean that I'm arguing for it. That means that I'm scrutinizing it and looking at the benefit that is attached through this amendment. So now, sir, I have to look at the potential harms, because that is one benefit that I mentioned. But now, let's look at the potential harms. When I go to this insertion of Section 45D into the Constitution, sir, we know already that a member of Parliament could lose their seat. They lose their seat and they could be expelled. And that leads me to the question of, would that put a fear in that person, in that individual? Would that person freely exercise freedom of conscience, sir? Because here, we are basically, if this amendment is passed, we are basically allowing them that this individual who was a candidate, an elected candidate in a political party, that they could be restricted, they could be expelled. And sir, I think that it is punitive and it is a harsh dose of reality. So, sir, Mr. President, Section 45D raises a serious concern, and it should to the minds of the people. I want to turn now to the Constitution of Barbados, and I want to remind Barbadians that Section 11, may I state it, sir? It says, whereas every person, and this is from Chapter 3 of the Constitution, Section 11 of that chapter, the chapter that is one that is universally accepted already in this country, Mr. President. It says, whereas every person in Barbados is entitled to the fundamental rights and freedoms of the individual, that is to say, the right, whatever his race, place of origin, political opinions. So he has a right, he or she has a right to political opinion. And that is to be enjoyed. That is not to be snatched away, even by an amendment, Mr. President. And as you see at subsection D, freedom of conscience, of expression, and of assembly and association. And, sir, a member of parliament should enjoy freedom of association. They should enjoy having political opinion. Now I take you to section 21 of the Constitution. Section 21 reads as follows: except with his own consent, no person shall be hindered in the enjoyment of his freedom of assembly and association, that is to say, his right to assemble freely and associate with other persons, and in particular, to form or belong to political parties, or to form or belong to trade unions or other associations for the protection of his interests. Mr. President, this means that this is a right in the Constitution, which is the guiding light, the guiding principle for society. And if there is an amendment that will pass in this honorable House, sir, we definitely have to ensure that this right that citizens have enjoyed for years, thousands of years, is not affected. Because you see, sir, further to this, the Parliamentary Commission